An earthquake. It's the release of pressure against two opposing forces. Well, that's what happened with regard to the Montgomery versus Carib decision. An earthquake shook the transportation industry after that May 2026 Supreme Court decision. The fault line that we have in that circumstance was that there was a protection for freight brokers for more than 30 years in the Federal Aviation Administration Authorization Act. And that said that transportation generally was preempted by the federal government. States couldn't touch it unless it was a matter of dealing with safety. Well, plaintiff attorneys have said, well, look, bodily injury suits, those involve safety, and so those should be outside of that preemption, outside of that protection. Several federal circuits agreed with them. A number didn't. Ultimately, when that happens, those cases go to the Supreme Court. And it did in this case, and the Supreme Court ruled 9-0 that the Federal Aviation Authorization Act did not preempt bodily injury lawsuits against freight brokers. The initial reaction for this was, well, the wall came down. It's a situation where the protection that was afforded is no longer there. And now the courts are open. There's no early dismissal on this. The plaintiffs can come through the door and the litigation proceed. Initial reaction by the press and those they interviewed was, well, what's the big deal? As we said earlier, several of the circuits had already said that's the law. It's just a matter of extending it to the rest of the country. And besides, Justice Kavanaugh, in his concurring opinion, said that the brokers can still defend themselves at trial by showing that they chose a reputable trucking company. Well, the analysis afforded by those folks is legally correct, but it misses the reality of what this means from another instance. First of all, the main shock, litigation economics. It's the arithmetic no one's talking about. And I became an attorney to avoid math, but this is right out there. Where there's an $8 million claim, let's say the trucking company only has $1 million in coverage. Guess where the balance is going to be sought from? By the plaintiff attorney, from the broker. Now with the broker exposure, they are being attempted to be made the excess carrier, the excess provider with regard to anything above what the insurance company does. Drive settlements on this, but because before this, the plaintiff got $1 million, the gap was the plaintiff's problem. Now with the brokers named the defendant, in the example we gave, the $7 million gap is what they're going to come at them for. So between the broker's insurance and their balance sheet, they're going to look at them to try to fill it. What this does is give the plaintiff attorneys leverage against the brokers. And they'll say, look, if you want to take the risk, that's up to you. But in this world of nuclear verdicts, if you don't pony up, if you don't have some protection there, we'll go to court and see what a jury does and how far it'll go with this. The plaintiffs are capitalizing on this. While some people say, well, look, this was the law before in various cases, it wasn't across the board, it wasn't clear, and it wasn't a certainty to the plaintiff attorneys. Now it is. Plus, in hitting the headlines, a number of plaintiff attorneys in their blogs or even direct emails are telling their fellow attorneys who don't have the operation they do, hey, look, we can handle it. We've got the resources and we've got the experience in order to bring these broker claims that are more complicated than what you do in your daily actions. Refer the cases to us and we'll compensate them for you. Think about it. If a plaintiff attorney refers it to one of those larger firms, wouldn't they expect, if the reason they're referring it is because of their ability to handle broker liability, that larger plaintiff firm's going to sue the broker? What we come down to and what this generates is a nuclear threat. And while not every verdict goes nuclear, we have created a world in which there is that potential. And because of that potential, that is driving these excess settlements that we see in our world. Excess, Sedgwick, insurance folks, released a report that said, look, 10 years ago in 2016, 12% of our cases went to trial. Now we're down to 1.25%, almost a tenfold decrease in what it is. And while the current verdicts are basically tracking inflation in terms of severity, the settlement severity growth has been 3 times that of verdicts. So the battlefield has moved. It's no longer in the courtroom. It is now in the negotiating table. It's now in the verdicts that they're trying to avoid rather than the fights that they're trying to fight. Kyle Schwarber. Several months ago, Phillies are playing the Pirates. Pirates are up by a couple runs late in the game. Bases are loaded. Schwarber comes to the plate. He had already hit 2 home runs. Pirates thought about it. Here's the deal. We're going to walk him. We'll give up the run to avoid the grand slam. Well, that's what we're seeing with regard to the litigation environment right now. We're seeing a situation where settlements are being overpaid to avoid the grand slam of the nuclear verdict. We had a number of aftershocks as a result of this, just like we'd see in any type of earthquake situation. The first one is insurance. There's a coverage gap that many brokers don't know they have. There's a separate video I've done interviewing Tommy Rook, the top in terms of insurance coverage and forms. And what I learned from him is that many brokers now have contingency coverage that comes into play if the trucking company's coverage doesn't defend the trucking company's negligence. Well, the problem is this whole game has changed now with Montgomery. It's not the trucking company's negligence alone, but it's that of the broker for selecting a negligent, ineffective, risky trucking company. Direct negligence of the broker. The question comes, does the broker's policy cover it in this new era with this new potential? The brokers now are looking and saying, well, look, to protect ourselves, we want the trucking companies we broker freight to have higher coverage. One instance I've heard of is $5 million of coverage that they want. On the flip side, the brokers themselves need more coverage because the coverage they're carrying may not insure the particular loss they're dealing with on this. Aftershock number 2, contracts, indemnification, anti-indemnity statutes, choice of law. Because here's the deal. First thing is, can we insure against it? And second thing is, can we put the risk off on somebody else? Well, that's what they'll try to do contractually. There are many types or several types of different contractual indemnification, broad form to provide protection from everything, even the broker's own negligence. Many state laws don't permit such allocation of it. Intermediate, where it talks about indemnifying against respective, and limited is even more so. But the anti-indemnity statutes within 46 states that have them may negate some or to an effect part of the indemnification provision. This is something trucking companies have to look at on this situation. Number one, review the broker forms, broker contracts that are presented to you. It's no longer a matter, I'm going to sign it to get the freight. You could be stepping into a situation that you can't afford. Number two, is there an anti-indemnification statute that prohibits this to some effect that may apply? Or what state law applies to it? Because choice of law, which state is going to interpret that, is going to be key in these type of things. We know there are 4 states that don't have any indemnification statutes. If the broker's form says that one of those 4 states apply, you've got no protection from the anti-indemnity provisions on it. The choice of law consequence, if there's no choice of law clause, you have no certainty. In what you are left are the vagaries of a court deciding not just what state's law applies, but what state law decides what state law applies. It's a Gordian knot. It's a law school problem. And the indemnification, ultimately, that's only as good as somebody's ability to pay. Yeah, I'll back you for that. But if you don't have the money, that's never going to happen. The final aftershock is carrier selection. It is a tsunami that's restructuring the industry. Look, 95% of the carriers do not have a rating. Only 40,000 carriers are satisfactory. 10,000 are conditional, and under today's post-Montgomery circumstances, I'd be surprised if many, if any of those conditional rated carriers would get loads from the brokers to expose themselves. You know, what we need to do is to make sure that there is a defensible carrier, that you present yourself as a trucking company to a broker, and as to why you are defensible, why the selection of you is not something they can be criticized from. It falls into the category of what the justice said in the concurring opinion was a reputable carrier. You know, what is your safety rating, CSA scores? Do you have anything in alert? If you're one of the 95% that are unrated, Where do you stand with regard to the current indications of it, particularly with regard to your crash history? Because that's going to be the primary indicator out there as to what's involved. And don't be surprised if there's ongoing monitoring to see what it is and how you're doing so that it's not just a 6 or 12-month spot check, that they know as a broker immediately on this. Similarly, don't be surprised if the brokers, as many insurance companies are doing, are requiring onboard video recording. Number one, they are an exoneration tool. The times that I've heard of them exonerating the trucking companies, showing they're not at fault, has always exceeded what shows them at fault. Besides, where there's inward-facing cameras, it's a coaching device to reduce the risk by training your drivers through videos the same way professional athletes train. Document the decision to choose the carrier. If that broker wants to choose you, what documentation do they have as to your safety, and have they followed the written policy? Look, whatever you do before the lawsuit is evidence. What you do afterwards is backfill. Today's the time to take action. It is now in today's world, it's going to be a question of quality, safety, not quantity, price. We see ongoing tremors out there. We see where C.H. Robinson has already tightened the standards after the Supreme Court loss. We see where J.B. Hunt expects dedicated to be boosted as a result of the decision because it'll mean more freight going to a known monitored carrier. We even see new carriers out there, the way Amazon has set up and now looking to set up its own LTL. Look, here's what we looked at. The fault line, preemption is gone. The main shock, litigation economics change. There's leverage for settlements. Aftershock one, insurance changes. Does the broker have the insurance that's going to cover you in this type of a loss? Number two, contractual challenges. Are the agreements you're being asked to sign by the brokers throwing the loss over on you? And then the ongoing tremors, the industry impact that's out there. Look, the legal standard may be narrow. It may not be much of a change from the legal perspective, but the litigation economics, the repercussions through insurance contracts and now drivers and carrier selection, those are going to be instrumental. That's the background. If you're a trucking company, you need to know the impact of this decision and know what you need to do to protect yourself.